The Delhi police on Thursday has filed a charge sheet against Brij Bhushan Singh. The charge sheet contains more than 1,500 pages. And ever since the charge sheet has been filed, there has been a lot of speculation about the charges that have been pressed by the Delhi police. To discuss this and a lot more, today we have Mr. Anuj Kapoor. He's the advocate on record in the Supreme Court. So welcome to the show, Anuj. Welcome to the
Thank you,
Federal.
Sudha.
So Anuj, let's begin with this very basic understanding of this charges, that have been pressed. Do you think these charges are watertight enough to ensure a conviction?
Siddharth, let me clarify a couple of things before I give my opinion. So, this is a POXO case. The Delhi police has in fact filed two charge sheets. One in a
Right.
POXO case, which has been filed, not a charge sheet, it's a closure report that has been filed in a POXO FIR. That closure report has been filed in Patiala House Court. In addition, a charge sheet has been filed in Rouse Avenue Court, which is the court where the court for MP and MLA trials, there are special courts in Rouse Avenue Court. So a
Right.
charge sheet has been filed against Brij Bhushan Singh and one more accused person for three sections under the IPC.
Right.
So let me first point out that both of these are charge sheets that have been filed by the police in the court. So neither do I, and I assume you also may not have a copy of what the police has filed.
Right.
So it is impossible for me to comment on whether the charge sheet that has been filed is a watertight case which will lead to conviction or which will lead to acquittal. I am not in a position to comment. Right?
Yeah,
A
I
charge
was I
sheet.
was about yeah, right. I was about to come to the cancellation report in a bit. So,
Okay.
I first wanted to talk about the charges that have been pressed, especially if you look at the section 354, 354A and 354B.
Right.
I mean, uh, 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 people and lawyers especially, they have been saying that, there is an attempt to sort of water down the case to an extent.
See again. One can comment on whether there has been an attempt by the police to water down and to make a weaker case only once we have access to the FIR. Now, even the FIR in these kind of cases where there is a prosecutrix who's a woman or there may be a minor person who's making allegations under POXO Act, these are FIRs that are also confidential. There are non-sensitive cases in which the FIRs are available on the Delhi police website. But in these kind of cases, even the FIRs are confidential. So only the parties to the case will have access to the FIR or somebody who they have shared it with. Right. So whether
Right.
the police has made a weaker case, one can comment only by saying seeing what are the allegations that are made
Mhm.
in the FIR and what is the final conclusion fact finding that the police has done.
Right. Right. So, I mean, if one was to see a more broader understanding, a more, the finer print, so to say, uh, from yesterday's charge sheet, what does it appear? What does it appear at the first reaction? What does it appear?
See, it appears that the charge sheet has been filed uh, to keep up the promise that had been made by the sports minister, Mr. Anurag
Right.
Thakur. He had
Okay.
said that the charge sheet will be filed on or before 15th of June, if I'm not mistaken. And the
Right. On
police has
15th of
followed
June.
that
Right.
timeline,
So
right?
is it an
In
attempt only to adhere to the timeline that has been stated by the minister?
See, I can tell you what happens in normal course. In normal course, when an accused is arrested, then there is a certain timeline that the police must follow to file the charge sheet. Otherwise, the accused will be entitled to default bail under 167, under section 167 of the CRPC. When the accused is not arrested, those are usually the cases where the police takes its own sweet time to file the charge sheet. So in this case, the FIR, I believe, was registered only
It was
after
registered on
Supreme
the
Court
28th of April.
28th
Right.
of April, after the
Right.
Supreme Court had issued notice in
Intervene.
the
Yes. Yes. Yes.
petition that had been filed in the Supreme Court. So 28th of April, FIR is registered, and in less than 2 months, the charge sheet is filed. So this is sort of breakneck speed for the Delhi police, I would say.
Mm-hmm.
But I am again unable to comment because of my incapacity, because of my lack of knowledge of what the contents of the charge sheet are, as to whether this is a honest job or this is a cover-up job or what kind of sort of investigation the police has done. But certainly the police has the fact that one more thing I can point out, there are three types of reports that the police can file every time that there is an investigation carried out by it. One is a charge sheet, which is basically the police recommending that yes, these persons should be prosecuted for certain offences that have been found to have been committed by the police. So the fact that the police is saying that there are four offences: 354, 354A, 354D, and 5061. Four offences, the police has found enough material to recommend prosecution to the court. That is as far as one charge sheet is concerned. Coming to the other charge sheet, the police has found that in the POXO FIR, there is no merit,
Yeah,
and therefore the
I was just coming
I
to the, I was just
right,
coming to
right.
that POXO
Huh.
case. So, just to, continue with this discussion, there was this landmark guideline, rather guidelines, which was provided by the Supreme Court in the Satyendra Kumar Antil versus the CBI case, which stated
Right.
that granting bail in cases where a person has not been arrested at the time of filing of charge sheet, so the probability of that person being arrested after filing of the charge sheet is reduced considerably.
Is
So
negligible.
is almost negligible, right? So do you think this case? So obviously, in this case, this precedence will apply.
Yes, it would definitely apply. Uh, the judgment that you have cited, Satinder Kumar Antil, prior to that, several judgments, including Arnesh Kumar, they all point out to the fact, to the principle that whether a person should be arrested or not is a prerogative of the police, of the investigative agency.
Right.
Once the person has been arrested, it may be up to the court whether to release him or her on bail.
Mm-hmm.
Right. So here the
Mm-hmm.
police has exercised its prerogative and chosen to not arrest any of the accused persons.
Okay.
Whether that is correct, not correct, there are several factors that have to be considered. But it is for the complainants to sort of challenge. I think my electricity has gone. It is for the complainants to challenge that in a court of law, and the court's first response only would be that, see, the police has not arrested, so it is not within the remit of the court to direct that the accused should be arrested.
Right.
So one plea that the complainants can take is that the investigation has not been carried out fairly and the investigation should be handed over to another agency
Mm-hmm.
or to an SIT, which was the,
Right.
in fact, the prayer before the Supreme Court in the 32 petition.
Right.
Right. So that prayer the court did not grant. There is no SIT. Up till now, I believe there has not been any demand that CBI should investigate. So Delhi police is the one investigating. Delhi police has taken a call that it does not want to arrest the accused persons.
So
Now
now,
it will
yeah, yeah. So now, what are the options that are available for Brij Bhushan Singh?
he will have to, when the court summons, when the court takes cognizance of the charge sheet, which I believe has not been taken up as yet,
They,
when the court takes
they'll meet on the
cognizance.
22nd of June.
Right. So
Yeah.
on that date, if the court takes cognizance, the court will issue summons to the
Right.
accused person.
Okay.
If the accused person enters appearance upon issuance of summons, then the accused person will take bail from court, which will be like a formality in terms of the Supreme Court judgment in Satinder Kumar Antil. They will just have to furnish a bail bond and
Mm-hmm.
assure to the court that they will follow the process of law, they will not flee from justice, etc.
Right.
Right. So that will be a formality. They will have to first take bail and then the matter will proceed as per the CRPC. There will be arguments on framing of charge. If the court finds that, yes, based on the charge sheet, offense is made out based on what has been stated only in the charge sheet, without considering the defense that the accused may have. Accused is not entitled to plead its defense at the stage of consideration of the matter on charge. At that stage, only the charge sheet that the police files, only that is considered. So that will be the second stage. Once charges are framed, then the matter will go to evidence. So the evidence of witnesses, the complainant, the victims, those will be recorded. There will be cross-examination on behalf of the accused person. Finally, if there is any there will be statement of accused. Accused persons will be asked to give their position on each incriminating circumstance. This is
Mm-hmm.
how a criminal trial proceeds.
Right.
After prosecution evidence, accused persons will be asked to give their give their response on each incriminating circumstance. And after that, they will be asked whether they want to lead defense evidence. After
So
that, the
now,
final judgment.
okay. So now coming to the POXO case, Mr. Kapoor, since you specialize in POXO cases, this cancellation report, there's a lot of confusion over this cancellation report. The police has filed for a cancellation report in the Patiala House Court. So what exactly is this meaning of this cancellation report? I mean, is it that all the POXO charges that has been leveled against him initially, I mean, although the charges were taken back by the minor couple of weeks ago, but the initial registration of the case under POXO, has he been completely absolved in that case, or what is it? What is this cancellation report? Can you explain a little?
See, cancellation report in general parlance would mean that the police is not recommending prosecution. The conclusion of the police, whatever may be the fact finding, the police may have found incriminating evidence, which means evidence against the accused. The police may have also found exonerating evidence. That means evidence material which is in favor of the accused. And the final conclusion that the police is drawing is that it is not wanting to recommend prosecution. That is when the police files a cancellation report. It is
Okay.
up to the court whether the court will accept the cancellation report, meaning accept the version of the police, or the court can take a different version. The court can say no, based on the investigation that you yourself have carried out, I am coming to a different conclusion and I am going to proceed for prosecuting the accused person. So the
Right.
court is mandatorily required. One, the police is required to inform the prosecutrix, the victims, about the filing of the cancellation report. All the complainants, victims, they will have the opportunity to file a closure report, a protest petition. I'm sorry, a protest petition, which is in opposition to the cancellation report that the police files. So
Mm-hmm.
in the protest petition, the complainant would argue and try to persuade the court that the conclusion of the police that there should not be prosecution is ill-founded and there in fact should be prosecution. So the court will have to take its independent judgment on whether there should be prosecution or there shouldn't be prosecution. So merely because the police has filed cancellation report is not binding on the court. Right. Second aspect is what is the basis of the police filing cancellation report. I can hazard one guess. It probably wouldn't be that the complainant prosecutrix is a major. Had she been a major, then at least if the police had found that some offense had been committed, the police should have filed a charge sheet in the MP MLA court in Rouse Avenue court. The fact that the police is filing this is my speculation, the fact that the police is filing a closure report means that police is giving its opinion that according to the police, no offense has been committed. It is not on the question of majority or minority of the victim that the police is filing a closure report, but on the aspect that the police feels that no prosecutable offense under POXO or under any other offense for that matter has been committed against that particular victim in that particular FIR.
Okay. So if I was to sum up for our viewers in a very simple way, that now the court has three options with it, right? First, we can say that the court can take cognizance of the cancellation report and it can say that, okay, we are happy with your submission. Second, it can say, it can, reprimand the police and say that, you have to continue with the investigation and we are not happy with the report that you have cited. And third is it can ask the victim, the victim in this case, the minor, to depose in front of the court and, ask for her opinion, right? These are the three
Not
things that
not
broadly.
deposed on the third option that you stated. Not deposed. The court will not ask the victim to depose. The court will ask the victim whether they want to oppose the cancellation report. And if the
Okay,
victim is aggrieved by the cancellation report, then the victim ordinarily would oppose the cancellation, would file what is called a protest petition.
okay. Okay,
So
so these are
there won't be any evidence, there won't be any deposition at this stage.
okay,
Based on the investigation that has been carried out, one view can be taken or another view can be taken, and the court always has the power to direct the police to do further investigation. And
right.
even the
So
complainant can ask the court that further investigation must be in this particular direction or that particular direction. The complainant can always suggest
mhm,
particular leads that the police has deliberately or by inadvertence not followed through.
right. So in effect, that the POXO charges that were initially leveled against Brij Bhushan Singh, it has not ended, right? It is, I mean, it is up to the courts to take
Not at
cognizance of
all.
the matter.
Yes.
So, this entire initial celebration that, the case has been, dissolved and the POXO charges have been completely been taken off. So it's not true, right?
It is premature to say that, I would say,
It is premature to
right?
say that
Because
because,
it
yeah,
has not attained finality. And another aspect I can touch upon is
right.
I had uh, read about comments by other
Mhm,
lawyers
mhm,
when news was floating around that victim has withdrawn her allegations.
right.
So there were some lawyers who were saying that a POXO minor victim is
Mhm,
incapable of withdrawing the allegation. I
mhm,
have a slightly different take on that.
mhm,
Each person under the Indian Evidence Act is competent to be a witness. There is no specific stipulation in the Evidence Act that only a major can be a witness, only a person above 18 years can be a witness. As far as uh, what is the weightage to be given, it is something that is a matter of appreciation. That is something on which a judgment call has to be taken at the first instance by the police and at the second instance by the court. So, till the time there is evidence in court, the court and the police will only rely upon the statement that has been recorded. It may have been recorded before the police. In POXO cases, in rape cases, it is also recorded before a magistrate under section 164 of the CRPC.
mhm, mhm.
So what has to be seen is what is the contents of the statement under 161, under 164, which have been made by the victim. So merely because in a subsequent statement a victim may have taken a certain stand does not absolve or does not negate whatever allegations may have been made in the previous instances. So this is a judgment call, and it will be premature to say that this finding or this conclusion that the police has arrived at is definitely going to be correct, that there is no material enough to prosecute. And it may also be incorrect to say that a victim cannot by herself withdraw the allegation. It depends on whether the victim's version is believable, whether if the victim was, say, 6 or 8 or 9 years old, then yes, certainly there would be a requirement to seek some corroboration, some affirmation from the victim's parents or guardians.
Right,
But if the victim is 16 years old, 17 years old, then certainly the victim's statement, even though to the police, even though to the magistrate, has to be given a certain weightage. So I wouldn't go as
no,
far as saying that just because the victim may be a minor, she cannot withdraw allegations.
right. So, Mr. Kapoor, if you can help us understand, since you have dealt a lot on the POXO cases, in various POXO cases. If you see right from the initial stage of the filing of the case under POXO, which happened on April 28th, up till now that we are in mid-June, how the case has progressed. Do you think in a normal case, if a normal person was accused under POXO charges, do you think the case would have shaped in this manner or it would have been different?
It most likely would have been different. In ordinary course, the norm that I have seen, at least as far as criminal side practice in Delhi is concerned, is that in a POXO case, invariably the police will arrest the accused person. An exception can be when the police, for sure, is very confident that this was a case of teenage romance, it was a case of elopement. In these kind of cases, also under pressure from the girl's parents, the police normally ends up arresting the uh, teenage boy or a boy who may be in his early 20s. So my experience up till now has been that in POXO cases, police does arrest the accused person. But here, a differentiating factor, which is also a very critical factor, is as to what is the time of the alleged offense. Because ordinarily, the FIR comes to be registered soon after the offense has been committed. In this case, there has been some delay. So, delay also can be a relevant factor why the police may not want to arrest an accused person. So, these are all factors to
This
be
is a
considered
this
by
is
the
a this
police
is a
in the
very
first
vital
instance.
point. This is a very vital point that you have raised, Mr. Kapoor. So, in what you are saying, in ordinary cases, or rather in normal cases, in most of the cases that you have worked upon, the filing of the case, the filing of the POXO case is almost very immediate to the offense committed, right? But in this case, there has been a time lapse, there has been a delay. Therefore, that might have prompted the police to actually not arrest the accused. That's what you are
See,
saying, right?
I am saying also that the fact that the police has filed a closure report means that the police itself does not believe an offense has been committed. So there is no question that the police would have arrested the accused person for the
Right,
POXO case,
right,
right? There may
right.
have been a possibility that at the very initial stage, when the allegations just had been leveled, when the FIR had just been registered, there may have been some reason to arrest. But considering the delay, etc., and considering the stature of the accused person, it is not something that sure shot will happen, right? We know it's a matter of common knowledge as to the stature and the Bahubali kind of nature of Mr. Brij Bhushan Singh, right? So he being a sitting MP from the BJP, from the ruling government, is is maybe a factor which has. I'm just speculating, or it could have been a factor which has played, right? Moreover, the
So
fact
once
that
the
the final.
so I mean, see, if you are to understand it, on the 28th of April, a minor files a POXO charge. She files a charge, which is under the POXO case. Now, it would have been incumbent upon the police to give, arrest Brij Bhushan immediately and then to proceed with the investigation. That is what
No,
happens normally in
I
POXO
wouldn't
cases.
say
But
I wouldn't say it would be incumbent. I have seen it happening that POXO cases lead to arrests of the accused person. But like I said, arrest is the prerogative of the police. It is never incumbent on the police to arrest, right? And there are justified reasons to not arrest when the complaint is coming after a time gap, after a delay, even though the delay may be justifiable by some reasons.
so in hindsight, if we are to look at it, it's, I mean, even if somebody has if somebody has committed an offense, and if there is a time lapse, so it works in his favor, right?
It works in always delay in lodging of the case of a criminal case, delay in registration of an FIR invariably works in favor of the accused persons.
It always acts in the favor of the
Yes,
accused.
yes, yes.
So now, having seen this, having visited the broad contours of this, charges and what has been leveled against Brij Bhushan. So how do you think, how do you think the case, I mean, although it's a very speculative question, but how do you think the case is going to progress from here on?
See, as far as the POXO case is concerned, I don't know what to believe. There are reports which say that the victim has withdrawn the allegations. There are some reports that I also saw where the father of the victim is saying that no, we have not withdrawn the allegation. So I don't know what is the reality. If the victim has withdrawn, then like I said, there may be one withdrawal, but there may be two other statements to the police, the written complaint based on which the FIR is recorded, a statement before the magistrate. So a cumulative sort of view has to be taken. Merely because there is one statement in which the allegations are withdrawn should not be decisive, should not be treated to be decisive when there are other statements also where clear allegations have been made. So this is something that has to be appreciated, that has to be examined. The police has examined and has taken a certain view. It's up to the courts now whether they will
Okay.
accept that. But and it may be that the sources sort of revealed reports which say that the victim has withdrawn her statement may turn out to be incorrect, because these are
Right,
sources, we don't know the identity of the sources,
right, right. So I
right?
mean,
So unless we
so
see the charge sheet, unless we see the closure report rather,
Mhm.
we are not in a position to say as to what is the nature of investigation, what is the seriousness and credibility of the statement given by the victims, whether the statement has actually been, allegations have been withdrawn or not. This is all something that can be commented on after seeing the report.
Okay, so I mean, it would be better for us to wait till the 4th of July, and that will give a much clearer picture, right?
Right.
Yeah. Okay.
But
So
yes,
yeah.
it can certainly be said that if the victim wants to, then the victim can pursue her remedies and she can file a protest petition. And this is not going to rest merely because the police has filed a closure report.
Okay. So thanks a lot, Mr. Kapoor, for putting things into perspective. The broader conclusion that we can draw from the today's conversation is that it's not that the cases, the POXO cases that were leveled against Brij Bhushan has been laid to rest. It's actually now it's at the court's discretion when the courts take cognizance of the report, how it wants to go ahead with the investigation. So thanks a lot once again for joining us at the Federal.
Okay.
And this is Siddharth Chakravarti for the Federal.
Subscribe to the Federal's YouTube page for more news and updates.